If you're buying a business in Canada and you're relying on financial statements, you're taking a serious risk. As an Ontario corporate lawyer, I have seen buyers inherit lawsuits, hidden debt, and security interests they didn't even know existed simply because proper due diligence was not done. As recently, one of the cases that came into my knowledge, a buyer purchased what looked like a profitable service business. There was strong cash flow, loyal customers, clean financials. Everything looked fine on paper. What they didn't know was that the company's equipment and receivables were already subject to an old security registration under PPSA, registered years earlier and never properly discharged. After closing, and some while just passed on, the lender enforced that security. The buyer suddenly discovered that assets they thought they owned were actually collateral for someone else's debt. That issue didn't appear on financial statements. Due diligence is not paperwork for the sake of paperwork. It's the legal and commercial process of verifying what you're actually buying and not just what seller tells you. For a small and medium-sized business, this step is often rushed or skipped because it seems not necessary or cumbersome. In reality, it's often the cheapest insurance you can buy in an acquisition deal. A few issues that due diligence is designed to uncover can be hidden security interests registered against assets under the PPSA, outstanding tax areas that can follow the business, threats of execution, or enforcement actions already in place, IP that business uses but doesn't actually own, restrictions on share transfer or control issues if you're buying shares, Bank Act security that overrides other registrations. None of these are visible from a profit and loss statement as well. Due diligence looks very different depending on whether you're buying an asset or shares or they're an amalgamation or any other form of business acquisition deal. In a share deal, you inherit the company, liabilities, and everything. That means corporate records, security law issues, execution searches, and historical compliance really matter. In an asset deal, the focus shifts on ensuring assets are clean, transferable, and not subject to third party claims. The structure of the deal determines the depth and the direction of due diligence. This is why especially important in Canada. What I generally consider while conducting due diligence, obviously it depends on the structure of deal, but just to give a general glance on the things that I go first on, it's the first thing is to review the corporate minute book of the corporation and to know how the records are maintained and what transactions have been taken in the past. Then I would also want to have a look at the contracts that the target corporation has done with other third parties. I would conduct various corporate searches to confirm ownerships and other liability related issues. I would do check on litigation records to see if there is any ongoing or previous litigation on the target corporation. Will ask for the access to get into the CRA portal of the target corporation and see its notices of assessments and determine if there is any tax liability. I would review employment law related records of the target corporation to determine any employment law related liabilities. Good due diligence doesn't just protect you, it strengthens your negotiation position. Issues uncovered during due diligence often lead to purchase price adjustments, holdbacks and escrows, specific indemnities, or in some cases, walking away from a bad deal entirely. This saves your investments. If you're considering buying a business, whether it's your first acquisition or part of a growth strategy, understanding due diligence is not optional. It's the difference between buying an opportunity and buying someone else's problems. Make sure you're looking under the hood before you sign.